Hi everybody. I'm David Baumser, a partner at Cantor Colburn. I'm in the intellectual property. It's an intellectual property focusing law firm, and I'm in the patent procurement department and the transactions department, which means I help inventors get their patents by dealing with U.S. Patent and Trademark Office, and then I help them deal with agreements that are required to protect their developed intellectual property, which could be patents or trademarks, copyrights when it comes to the agreement side. But on the other side, when it comes to procurement, I deal with patents almost exclusively. Sarah, do you want to go next?
Yes, I can go next. I'm Sarah Colburn. I also work at Cantor Colburn. I am in the litigation group as well as the transactional. I do a lot in litigation, but I also do the agreements as well, which is what we're going to speak about tonight.
Rich, I guess.
Okay. My name is Rich Gers. I work for a law firm in New York City named Haug Partners. Most of what I do is on the litigation side for intellectual property, and that includes both patents and also litigating contracts, agreements like what we'll be talking about today. And then I also help with drafting and negotiating and handling disputes about agreements. So this will be a fun presentation.
And we encourage everyone to speak up or raise your hand, and we'll answer questions as we go. Just makes it more lively, and every question is a good question, so please feel free.
Sure.
So just to begin, a quick overview of what we're going to talk about tonight, the types of intellectual property and transactions. Then Rich is going to discuss the NDAs, which is the non-disclosure agreements, the types, some examples. David is going to touch upon the collaboration with third parties, universities, or the US government. I'm going to discuss licenses, some more types, examples for you guys to see the language. Rich is going to discuss assignments, and then we're all going to touch upon the key terms just to see what you should look for in these type of agreements to protect your intellectual property.
Okay. And first of all, we've been talking about intellectual property and IP, but maybe it'd be good to take a step back and explain, well, what is IP? Because some people might have a lot of knowledge about it, and some people might have just a little bit of knowledge. So intellectual property comes up in all sorts of different transactions. And transactions are basically where people and or businesses work together to accomplish some sort of a shared goal. So a transaction could be as simple as like when you buy like an app for your phone, and you click on that, I agree to the terms and conditions, even though if you're like me, you've probably never read them before. Or more seriously, transactions can be like when you're getting a job and you're signing an employment agreement, or you're signing some sort of other contract as part of your job where you're doing business with another company. So transactions come up all the time, and whether you realize it or not, you've probably signed a lot of agreements that involve intellectual property. And intellectual property can include several different kinds of rights. One thing is the rights to inventions or designs, and those rights are often called patent rights because the US government and also governments around the world will allow you to obtain rights to practice, or not necessarily practice, but rights to stop other people from practicing your inventions. Another kind of transaction that comes up is works of authorship. So works of authorship can be anything from writing a book to, making music, taking a picture, making a movie. There's all sorts of different kinds of authorship that you can do, and those are protected with what's called copyrights. Another kind of intellectual property is what's called trade secrets. And just like the name indicates, trade secrets are some sort of information that you have that you want to keep secret. You want to keep other people from knowing whatever your secret is. So that can be things like software, the underlying code, can be data. Data is actually a very profitable and important intellectual property. And then know-how, knowing how to do something that somebody else doesn't know how to do. And know-how can be anything from like going to KFC and they'll have a recipe for how they make their original recipe chicken, or know-how can be knowing how to design or make a machine work. Know-how can be a lot of different things. And then finally are trademarks. Trademarks are, if you think about like a brand, like you think about Apple Computer and you picture that Apple logo, and that Apple logo identifies that device that you're dealing with is coming from Apple Computer. And that indicator of the source of the good has a lot of value to it. Think about Nike shoes with the swish. Trademarks are kind of intellectual property that's controlled through different kinds of agreements. All right, next slide, please.
And also just one comment there, data has become so much more complicated because of the international laws on the right to forget your personal data, right? So which is considered intellectual property, but also there are more restrictions now than years ago on who can handle what types of information and how they're allowed to handle the information. And we're actually putting together another presentation on that. So maybe that's something that we could give to you guys at a later event, but it's a real complicated and interesting field of intellectual property. So there are different types of transactions that implicate generation and ownership of intellectual property. Fee for a service, for example, a vendor A provides services to company B. Company B pays for the service and from vendor A, and typically owns generated intellectual property rights, although there are circumstances in which they wouldn't own those rights at all, or maybe own certain portions of the rights. And we'll discuss some of those as we go on tonight. Collaborative research, company brings an expertise, and one expertise, and another company brings another expertise to jointly develop this new intellectual property. Intellectual property rights, we say patent rights here, but all intellectual property rights, because you could have copyrights or even trademarks developed in these agreements, maybe jointly owned or maybe divided based on each other's contributions, maybe divided based on their core technology, because they don't want to let go of control of that core technology, and a variety of other reasons that you would divide up intellectual property. Asset or technology transfer. The company sells its technology and related patents to another company, and in those situations, all IP is assigned from one company to another. Ideally, each company going into an agreement wants to walk out owning the most IP it can own and paying the least amount it has to for the IP it's getting, and getting the most amount for the IP that it's giving to the other company. And in this situation, that's everybody's goal, right? But that just doesn't work equitably because of things we're just talking about whose core technology is implicated, or what the different companies are bringing to the table. And we'll go more into this tonight.
All right, so like I talked about a little bit ago, there's lots of different kinds of agreements that you sign. An agreement is just some sort of a contract. And one of the most basic agreements that probably almost anyone who has a job in a technical field has or will sign is called an NDA, which stands for a non-disclosure agreement. And a non-disclosure agreement is a contract between two people or two companies that puts restrictions on the ability to disclose the other person's information. So if you think about it in a real simple sense, okay, say you have a job and your job is working on developing a new machine or a new software program or what have you for your employer. Well, your employer doesn't want you to go to the local bar and start telling your friends about, hey, this is this great new thing that my company is going to be coming out with, because information has value to it. You know, I used an example of Apple, and you think about like the Apple iPhone. Well, Apple has this big competitor, which is Samsung, and the Apple iPhone and the Samsung Galaxy have been competitors for years. And each one tries to one up the other one in terms of the features and all the different bells and whistles that their phones have. They want to keep their secrets secret as long as they possibly can, so that way the other side can't come to market with that idea sooner. And part of the way they control all that is with NDA. So they have agreements with their employers, they have agreements with contractors, agreements with suppliers that restrict the flow of information. And that's what a non-disclosure agreement is about. Next slide, please. And, you know, one of the easiest ideas of NDAs to understand with is that you have different trade secrets that are involved with whatever business or whatever it is you're doing. And that's true whether you're an individual inventor where you're inventing something out of your garage, or it's true if you're a huge company. And you think about, like, one example of a trade secret is Coca-Cola. You know, they've got their secret recipe for the soft drink that they've been selling for over 100 years, and they want to prevent other people from making an exact copy of Coca-Cola. And Coca-Cola tastes a little bit different from, say, Pepsi, or, you know, going to Walmart and getting whatever the generic is over on the shelf. There's all sorts of different competitive business information that companies want to keep secret. And the way they keep it secret is by having contractual obligations with the people they work with to keep it, to have some sort of control. Next slide, please. And non-disclosure agreements can either be unilateral or what's called mutual. So an example of a unilateral non-disclosure agreement is kind of like the situation you have when you work for a company. All the secrets that you're basically signing rights to your company about are the company's secrets. You might be working for that company and doing lots of great and wonderful things, but at the end of the day, you've got a unilateral agreement, most likely, with your employer that says that whatever great and wonderful stuff you're working on belongs to your employer. A mutual NDA is usually when companies are doing business with each other, and each company comes to the table with certain proprietary knowledge, and that's why they're doing a deal with each other, is that each one has something that the other one wants. And part of the way they control that is with a mutual NDA. And these agreements are really important. So an example is one litigation that I worked on several years ago dealt with a situation where our client bought a small startup company. That small startup company had around 20 employees, and they developed this new drug product. And they developed this drug product. They basically partnered with our client to help them develop that product into something that they could market and get FDA approval for. And then eventually our client bought that company for $2.6 billion. That's billion with a B, because of this new drug product that the 20-person startup had developed. Well, before our client bought that company, the person who was in charge of R&D left that startup company and started up his own company. And lo and behold, it turned out that his own company was doing the same kind of stuff that his startup company did. But he had all these non-disclosure agreements that said that he shouldn't be doing that. And it turned into a litigation, and eventually the two parties settled. But you think about it from the point of view of the client that we worked for, who bought the startup company for $2.6 billion with a B dollars. They wanted to have control over the inventions that were made at this company they were acquiring. So hope whoever that is okay. So anyway, that's why you have non-disclosure agreements, because you want to control the rights to this information that you're developing or buying. Next slide.
Actually, can I jump in also, just to comment?
Sure.
Yes. So I also worked with a company where they had software engineers that developed some really interesting software technology, graphical interfaces, and behind the the interface processing, and a group of these engineers who had signed NDAs and assignments, which we'll go over later, so that the company would own everything they did. They couldn't disclose it. They put in like one of these backdoor access points to their databases and their drives that were held by the company. And when they went to the new company, they were able to track it and determined they went in and pulled everything out, and they're actually using it with the new company in violation of their agreements. And I think that there's a certain misunderstanding by employees who feel that their creation, their ownership. And while it's certainly reasonable, and you can empathize with how they feel, the fact is that they're getting paid for a service, and they sign these agreements, and they can't do that, and they could get into a lot of trouble. So it's something for everyone here to think about. Just when you are working for another company, chances are you've signed agreements that give away your rights to not only own it and use it, but even to talk about it outside that company. Anyway, so that's my 2 cents.
And then as far as the elements of a non-disclosure agreement, and we'll go through this more, but when you're signing the agreements, you'll see that they'll have an identification of who the people involved with or the parties are involved with, the purpose of that agreement, and very importantly, a definition of what's deemed to be confidential. So those agreements will usually define what's confidential and what's not confidential, because the scope of an agreement can affect whether or not that agreement is enforceable if it goes into litigation, like the example I gave.
May I ask a question?
Sure.
So what is the enforcement for NDA if either side breaks it?
So the enforcement for an NDA, if either side breaks it, it depends on the language of the agreement. Some agreements have automatic penalties. They're sometimes called liquidated damages. Sometimes the enforcement will go to arbitration, and sometimes the enforcement will go into federal courts, like the one that I worked on. And a lot depends on the nature of the confidential information and the potential value of that information. But the enforcement tends to be going into court, and it's civil penalties. And civil penalties can be either that you pay money, or that you can be what's called enjoined from using whatever information you were using, or both. So for instance, in the lawsuit that I was talking about, the enforcement potentially would have given, if the parties hadn't have come up with an amicable resolution, which frankly involved a lot of money, but it could have resulted in this guy who went off and started his own company, and that company basically becoming the property of our client. So you think about the time and effort and investor money that goes into building a business. Part of that enforcement is that business and the viability of the business and all the blood, sweat, tears, and money that went into starting that business could be taken over by the person you signed a contract with.
And at the time that the infraction is noticed, is there an injunction that stops people from doing things until such times as you can go to litigation or other things?
Usually it's you go to the litigation and you seek an injunction, if that makes sense. You can get a temporary restraining order from the court, or you can get a court order potentially to stop the activity. And it depends on the nature of the activity and the nature of the information involved.
But
So
you have to
sometimes-
go to the court, which may take weeks or months.
Well, with a temporary restraining order, it can take hours. But a litigation from beginning to end can take weeks or months or years.
Yeah.
but potentially a temporary restraining order can take hours.
I have a question here on the chat. Someone asks, why is there even a term period and how long is allowed before it causes problems?
So the term or the period of the agreement can differ, and there's a standard called reasonableness that's involved. So what's reasonable in the eyes of the court? So it depends on the nature of the information. So for instance, like with the, we talked about, the Coca-Cola secret formula. Well, that term could be forever because they have a way to prove that their trade secret, which is that secret formula, has a life forever. And forever typically is limited by, unless it becomes publicly known through no fault of the person to the contract. But other kinds of agreements might have a term that's much shorter. It might be months or years because the information just naturally becomes stale or valueless in a relatively short amount of time. So it just depends on the nature of the information that's being protected.
Right, like customer lists may be considered, an infinite period for protecting customer lists may be considered an unreasonable restraint on trade. Whereas a period that protects a trade secret that gives you a technological advantage may be reasonable to protect that for as long as the information remains a trade secret, software code, or the special sauce. So, Rich, I have a question for you. Or Sarah, what do you think about this? Party A wants to sign an NDA with Party B, and Party B wants to share the information it received with Party C, but does not want Party C to sign the NDA. What do you think about the risks associated with having, and I don't mean to put you on the spot, I mean, I have my own thoughts about this. The risks associated with having a party to the agreement share the information with a non-party to the agreement. They're not affiliates. They are literally a third party, but they want to share the information with them.
It all depends on how the agreement's written and what the agreement allows you to do. And with all of these agreements, it's, especially if you're dealing with information that's important, it really is worth reading because, if it's businesses negotiating with each other, they can negotiate the terms of the agreement to make it something that is palatable to both sides. And, with businesses, there can be situations where they decide to walk away from doing some sort of collaboration or what have you, because they just can't agree on the terms. So it really depends.
Yeah. My concern about having this Party C receive the information is that because they didn't sign the agreement, you've negotiated in the agreement certain choices of law, certain venue, like certain courts that you want to be able to drag each other into. You've agreed that an injunction can be perhaps obtained without showing of damages or requirement to produce a bond, which is what a court would be required to receive financially in order to allow an or authorize an injunction. So by having Party C, who hasn't signed this agreement, receive that information, you don't have any of that type of agreement with them, and it becomes that much harder to enforce your rights against a non-party.
Yeah, there is some. I'm sorry.
Yeah, I was just going to say, there's another question here in the chat. Sorry to interrupt.
Yeah.
Someone asks, what is the difference between an NDA and a CDA, confidentiality disclosure agreement? And then they ask, is an NDA's enforceability weakened by not including an attorney's fee provision?
So first of all, an NDA and a CDA, they're interchangeable. You can use either name and either one is correct. You don't even have to use that magic word. You can call the agreement whatever you want. But as far as NDA versus CDA, it's the same thing. As far as enforceability and whether or not it does or does not include an attorney's fee provision, those are the kinds of things that are often negotiated into an agreement. And sometimes the attorney's fees will be included in the agreement. So that way you've got kind of a hammer to hold over the other party's head and said, okay, well, you agreed that if you breach this agreement, you've got to pay me or pay my attorneys to sue you to enforce the agreement. So attorney's fees potentially can be, kind of a hammer to use against the other person who's signing the agreement, where you're basically making them financially responsible for you enforcing the agreement against them. But it all depends on what you negotiate, and it depends on the sophistication of the parties and the size of the parties. If you're dealing with a company that has 20 billion a year in sales, they're not going to care about attorney's fees. If you're dealing with a small startup that has 1 or 2 employees, then attorney's fees are much more important. So it depends.
And the company may also, in certain circumstances, agree to pay reasonable attorney's fees, but require that you allow them to choose the attorneys. So that they can control the fee structure even further, right? Have you seen, is that something you see, Rich, or?
I haven't seen that, no, but the important thing to remember about any kind of contract or any kind of agreement is that no one's forcing you to sign an agreement. You might force yourself to sign an agreement because you decide that you have no better option. But at the end of the day, agreements are meant to be negotiated, and the alternative to signing an agreement is to walk away from whatever kind of deal you were trying to make. Agreements can be anything that someone can put into words, as long as it's considered quote unquote reasonable by the court system.
And the purpose also, I'm not sure if you've already discussed this at each point here, why it's so important to have the purpose in the agreement, because it limits the ability of the receiving party to share the information. Usually there's language in the non-disclosure agreement or the CDA that says the information can only be shared to those of your employees or your directors or certain affiliates to the extent necessary in furtherance of the purpose. So if you have a very narrowly tailored purpose and you have 10,000 employees, maybe you could share you could be talking about a very small subgroup. But if the purpose is because the parties may wish to engage in future agreements, then you've now opened the door to the sharing your confidential information with everybody in their company, because why not? It could be all, within reason. So it's important to narrowly tailor the purpose defined in your agreements. You may have already said that, Rich. I'm sorry.
No problem. All right, ready to go on to the next thing?
So collaboration agreements. Okay. Depending on the contributions of the parties will define usually who gets to own the intellectual property, right? Like I said before, each party wants to own the IP. They want to own the most amount of the IP that's generated, but that may not be equitable. So a party providing more to the table, bringing more to the table, may be in a better position reasonably, or just because of their bigger stick, to walk away with more ownership, right? Depending on the type of input. So what could their contributions be? Funding, equipment, materials, background IP or pre-existing IP. So funding, let's say one party pays for all the research, right? They may very reasonably want to own all the IP. Or let's say the equipment is very unique equipment and very expensive equipment, and they bring that to the table. Materials similarly. Background IP. Let's say background IP is what you're bringing to the agreement that was created outside the scope of the agreement, and foreground IP is usually considered what's developed during the course of the agreement. Let's say your background IP is key to enable you to develop and practice the foreground IP. Maybe if that's the case, then the party owning the background IP would want to have a bigger stake in ownership. Does any of the IP implicate core business of one or the other? Let's say you have a software company that's developing network protection, ID protection software. And it's their core business, and they're hiring another company to put, to develop some type of, interfaces for the software or some other type of extraneous or small pieces of the intellectual property that really aren't, they're tangential at best to the core IP. You would not want the company that has the IP related to the core, the primary issue of protecting your ID over networks of communications. They would want to maintain ownership of their IP and develop and own newly developed IP over the other company that's developing, like, software interfaces or other ancillary tech. Pre-existing IP should be treated differently than IP generated, for reasons I was just saying. So
I'm sorry to interrupt, but I see another question there on the chat. This one's from Joe Goldberg. Is an invention done by two people a collaboration?
So there's joint inventorship. Certainly an invention where two people are considered inventors would be a joint inventorship situation. Collaboration, as far as agreements would go, I mean, people, generally speaking, collaboration could be anytime people work together, right? But in these collaboration agreements, it's when two companies are planning on working together, right? If you have two engineers working for a large company and they're tasked with working together to collaborate to develop something new, that is a collaboration, but doesn't fall under the guise of a collaboration agreement because they're just doing their jobs, right? So these collaboration agreements are about two companies working together that otherwise perhaps wouldn't work together for the purpose of developing something new. So yes, but not necessarily, right? Does that make sense? I mean, by the strict definition, yes, but by the agreements that we're talking about here, not necessarily.
Well, and the reason I'm asking is because people who are patent lawyers have told me that if two people or an invention have an invention, it's patented, each inventor has a right to the entire content of the invention's further use. There's not a split.
Right. So depending on, and Rich, I'm sure you want, I don't mean to monopolize this. I'm sure you have a lot to say here too. You want?
It depends, and we'll actually be touching on this a little bit later in the presentation, but you're exactly right that if there's multiple inventors on a patent, it's called joint inventorship, and each one of them has an equal right to the invention. But more often than not, there's something called an assignment agreement that assigns the rights to a single owner. So that's what takes care of the situation where joint inventors might have an equal ownership of a right to an invention. But technically that's correct, is that if two people invent something, they jointly own it unless they've already assigned it to somebody.
And if they happen to be working for the same company, then like Rich said, they probably would have already signed their rights to that one company. If they work for two different companies, those companies are hopefully working together under a collaboration agreement, and that agreement will determine who controls the intellectual property, and most likely those parties have assigned up their right to the companies anyway. You're in a tough spot if you're going to develop intellectual property with another person where you don't have an agreement to determine who owns what. Because if that other person feels the IP is worth nothing and you've spent a lot of money developing and getting a patent through the US Patent Office and maybe worldwide patent offices, the other party, absent agreement otherwise, can literally give it away. And it's really, you want to have agreements in place that prevent that from happening. The question is, can you license IP or an invention for a cost and a period of time? How does licensing come into play? Yes, we'll get into licensing during the course of this discussion, if you have intellectual property and you want to give someone else the right to make, the bundle of rights associated with a patent, make, use, within the territory of the United States, if it's a US patent, to make it, to use it, to sell it, to offer it for sale, to export it out of the territory borders of the United States, import it into it, right? And you can license all those rights. You can license some of those rights. You can license in fields of use. And Rich, again, I feel that, you want to jump in here.
No, that's good.
Yeah, so yes. And how does licensing come into play? It's get yourself someone who knows how to write these agreements and find a party that's interested, or you can find a brokerage. There are brokerage firms that can help you perhaps market your IP. Most law firms don't do that, but because it'd be a conflict of interest, but you can have your IP marketed, or you can market it yourself. Okay. Let's see. So defining background IP, rights owned or controlled by a party prior to the effective date of the agreement or generated by the party other than through the performance of the agreement. In other words, everything that happens outside the scope of the agreement. If the agreement is to develop a widget and someone's developing a manufacturing process that can be applied to anything, including a widget, it's outside the scope of the agreement. It has nothing to do the widget itself. Ultimately, it's not directly tied or controlled by uniquely applicable to the widget, and it's considered background IP. Access to background IP, a license, you'd want to make sure that if you're developing foreground intellectual property, that once that's developed, you have a license to the background intellectual property from the other party that was collaborating with you. And why? That type of license to background intellectual property is considered effectively a covenant not to sue. You don't want to look over your shoulder when you're practicing generated intellectual property so that you wonder whether or not the company you worked with is going to come after and sue you because you're utilizing some of their basic IP, right? If they have material. Sorry?
Someone needs to mute.
Okay, thank you. So let's say you're developing a new widget and the company you're working with developed the material for the widget. But ultimately the widget is something that you're collaborating to develop and you want to get out in the market. Or you want to sell it. You want to make it and sell it. You want to get a license to the background IP, which is going to be the material used to make the widget, because you don't want to worry about when you go and sell this thing and the other companies can come and sue you for using the material that you need to use to make the widget and sell the widget. And that's, again, it's basically a covenant not to sue. Okay. So there's different types of ownership, and everybody when we're speaking here, please feel free to jump in. Joint ownership, absent a contractual arrangement, like Rich was saying before, each co-owner, each inventor is a joint owner, or each co-owner of maybe the assignments can grant a non-exclusive license without accounting to the other co-owners. But you need all co-owners to get involved for standing for a lawsuit. And the downside to joint ownership is a loss of control, like I was saying before, in the market use of your IP. You may feel the IP is worth a lot, the other co-owner feels it's worth nothing, and then they undermine your ability to generate an income stream by just giving it away, right? Which is their right as a co-owner. Collaborations, you want to set out in advance, typically, ideally, who owns what IP developed from the collaboration. Otherwise, you wind up debating, arguing about, who's involved in inventing. Having if the collaboration says inventorship determines ownership, that'll be a problem, because a lot of times engineers, technicians, scientists, innovators are terrific at inventing, They're not terrific at identifying who's an inventor. Neither are any of us because we're not at the table. So it's a tough time to argue after the fact who can own if you can say ownership is based on inventorship. So maybe you want to identify subject matter that each may own regardless of the inventorship, really sets it out at the onset, gives you some comfort going into it. But no matter what comes out of this, whoever's involved, the IP is going to be owned predictably. Or one party can own everything and then give a license back to generate IP to the other party, non-exclusive license, or even an exclusive license. Just, one party has control of the ownership, which actually, I think I've always felt that it's better to own than it is to license in. It's better to own and license out, which means you license someone else, and better to own than it is to jointly own.
This is Joe Goldberg again. I'm questioning your bullet there. Conception is the touchstone of inventorship. My impression was that in today's patent law, submittal is the touchstone of inventorship. It's no longer the idea, it's the first to submit.
Right. So we're talking there about a couple of different things. To invent and then to have priority to obtain a patent at a patent office, right? The priority to obtain a patent at the patent office goes to the first to file. But if you haven't conceived and reduced to practice, at least constructively, which means on paper, you have your invention with enough information so someone knows that you have an invention. There's a little bit, it's more verbiage there, but effectively that's kind of like it in a nutshell. If you don't have that, then you don't have an invention. And you can't file at the patent office if you don't have an invention. So there's certain minimum requirements before you can even go to the patent office with your concept. And so that's why conception is like the touchstone of inventorship. And then once you have an invention, you have the right to go to the patent office, and then you have the right to get the patent, providing no one else has beat you to the patent office, because the US is now a first to file jurisdiction.
Thank you.
So the other types of agreements are university collaborations. You have sponsored research agreements. We use when industry partners engage with universities for research. You'll have professors and graduate students doing research on a project that you're funding. You want to in these agreements, you'll have statements of work, and you'll have fleshed out terms. They're called definitive agreements. They define all the terms, the work that will be performed, clearly define the budgets and milestones, because universities have to be reimbursed for all of their expenses. Otherwise, state universities at least they have budgets that are given to them by the state, so they have to make sure any expenses that other than that are being paid, they're getting paid for. Negotiate sponsors' rights to pre-publication. Universities, their goal is to publish. When you work with the university, you have to understand their goal is to publish. So if you're concerned about publication of your intervention, then working with the university may be a bad thing for you, because they're going to want to publish. They'll give you a certain period of time to review. So if you come up with intellectual property that you want to patent, then so they'll give you time to review to identify that. They're not going to publish your pre-existing confidential information, but everything developed within the university under the agreement, they're going to want to publish eventually. And 3 different ways of you can have negotiate typically is an option to negotiate a license terms for any resulting IP, but you don't know what those terms are going to be. You just know that you have in your document saying there you will have the option to negotiate once IP is developed for license terms. You can pre-negotiate terms, but a lot of universities won't do that. Some will, which is great. So they'll tell you at the onset how much type of fee they're going to want for you to have a license to the IP developed. an exclusive license to any resulting IP. Again, a lot of universities will wait till after the IP is developed before they are allowed to, under state law or their own rules, the university, before they're allowed to even negotiate those things. It's important again to note that the university can be a very tricky entity to work with because their mission is to publish and capitalize and develop IP, regardless of the impact on the sponsor, regardless of how much you're paying. That's not ultimately their concern. University is a great place to test out the proof of concepts, and then seek private organizations to develop your technology, your intellectual property further. If you believe it's going to have true commercial value, you may want to not deal with the university after a certain point. What is considered as a core technology? This question just came up. It depends on the party. If a party is, if their Credit Karma's core technology is protecting your identifying issues related to your credit, right? Black & Decker's core technology may be how they're now maybe recharging their batteries to power their tools. But core technology and universities can be used for all of these types of technologies to help test proof of concept, and you get to a point where concept is proven and you go private industry where you have more control over ownership and publication. But a core technology, anything that gives you, that is your company's mission, primary mission would be your core technology. Rich, I know I'm talking too much here. You have anything to add?
No, I think what you said is right. I always think about core technology is, what is that technology that makes other people want to do business with you? So there's, two reasons that they might want to do business with you. One is because of the services you offer, but the other is that you have some sort of technology that other people don't. So core technology, kind of like David said, is a fluid concept, but you think about, or the way I think about it is, what technology do you have that makes you valuable because other people don't have it?
So I'm just going to jump to the next couple of slides because we have a little bit more to go through here, and I don't want to take up too much of our time. So university agreements, collaboration agreements, CRADAs, or when private industries will work, private companies will work with universities to jointly collaborate to develop a research and development agreements, and you want to define your contributions, and you have a lot of the same issues with universities anyway, but the outside sponsors also be very involved in the development of IP. Agreements between universities are interinstitutional, IIA, interinstitutional agreements. We haven't discussed that here, but that will discuss between universities who owns what, who's paying for what over a long term when it comes to protecting IP. And government contracts also another whole other beast. They're very interesting. They're very hard to negotiate. Government is the 800-pound gorilla in the middle of the room. They have regulations, FARs and DFARs. FARs are federal acquisition regulations. DFARs are defensive federal acquisition regulations. It's very interesting stuff. Not a lot of them to negotiate, but you can have creatives with them too. I've worked with companies that will work with different branches of the government, go in and develop new intellectual property with the government. So again, it's cooperative research and development agreement, and you define who owns what intellectual property. The government's going to want a certain rights to the intellectual property that's developed under it because it's using government funding. But it's a very interesting area of law if you wind up having to deal with, or interesting area for you, anybody here who may wind up having to negotiate and deal with the government for certain rights. So, Sarah, I know you've been waiting a long time.
Yeah, no, it's fine. This will definitely answer the question that came up with licensing and cost and royalties and everything like that. But just to give a brief overview, the difference between exclusive and non-exclusive licenses. Exclusive, the licensee is the only party permitted to use the license rights, where non-exclusive, the licensee is permitted to use but does not preclude other parties from receiving the license to the same or similar rights. Also, in licenses, there are restrictions that can take place, for instance, field of use or the territory that you're able to use those rights, the terms, which was also in the question, either research use or commercial use. Also, the rights to assign or sublease. In some licenses, the license can be granted to a third party by the licensee, but this language would be in the license agreement. And then also going back to the question that was asked, royalties for the license. This could be the amount paid to the owner of the product, and these terms would be laid out in the agreements. And then the next slide. So just so you can see the language here, exclusive versus non-exclusive, as you can see in the first one, party A hereby grants to party B and party B accepts an exclusive royalty bearing license. It says the language right in it. Versus a non-exclusive license, party A hereby grants to party B a non-exclusive license. And as you can see, reading through these, it also talks about the territory, the right to sublicense, or not being able to sublicense. So it says those exceptions right in the language, which you really want to look at when you're viewing these agreements, whether you're making one or signing one. This language is extremely important because it literally determines every single right you have, either protecting your IP or licensing IP from someone else. And then next slide. And this is also something extremely important, the ability to bring a lawsuit, or in other words, the standing to sue. So with exclusive versus non-exclusive, if you have an exclusive license with all substantial rights, you can sue alone. But if you do not have an exclusive license, non-exclusive license that doesn't have any rights to bring a lawsuit without joining the patent owner, or if you have an exclusive license without all substantial rights, you have to join the patent owner as a party in any lawsuit. So if you are considering or wanting the potential to sue an infringer, you should really look at these points that are in the middle of the slides: the scope of licensee rights to sublicense, reversions of rights, duration of license to grant, control over litigation, and limitation on licensee's rights to assign its interests. Overall, this is very important because if you don't have all the substantial rights, then you have to bring in that other party to any lawsuit you have. So it's really important to know whether you have exclusive versus non-exclusive, what rights pertain, if there's any exceptions, and basically if you have the ability to go after an infringer. And then
Okay.
Rich is going to talk about assignments.
Thank you. So assignments, the way I tend to think about assignments is intellectual property. The P in intellectual property is property. So you think about, other kinds of property that you have that are maybe a little bit easier to think about. So say you own property like a piece of land, and that piece of land has certain boundaries associated with it. And based on a survey or whatever, what property belongs to you and what property belongs to your neighbor, okay? And if you want to sell your property, you can sell your property to somebody else, and they're buying property with those same boundaries as whatever it is that you once owned. Intellectual property is really the same kind of an idea, where you are trying to define what it is you own. And if you're selling that to somebody else, the person who's buying it wants to know what are they going to own once they buy it, right? And assignments of intellectual property are the way you kind of transfer your rights to somebody else. And there are different ways to assign intellectual property. But at the end of the day, the way to think about an assignment is assignment of intellectual property is just where you're transferring whatever rights you have to someone else, okay? And when you transfer that intellectual property, you, just like if you're selling your property to, you know, a house that you own or whatever, usually you want to be compensated. And there's different ways you can be compensated. You can either be paid outright, where they pay you $100,000 for your house. You can also do it where it's by royalties, where it's like, okay, pay me as we go. So over the next 30 years, you're going to pay me, you know, a mortgage payment each month. Or it can be some sort of ownership interest. You could say, okay, well, I'm going to sell you kind of like a timeshare, right? I'm going to sell you the use of the property for 50 weeks out of the year, but 2 weeks out of the year, I'm going to keep those rights. Or the way most assignments of intellectual property have is with like an employer-employee relationship or a consulting relationship, where it's like, okay, you're going to hire me to do a job. And in return for you paying me my salary for whatever period of time, anything that I invent while I'm doing my job belongs to you. And that's part of what I'm being paid for, is I'm being paid to think. And part of being paid to think is that you're going to own whatever inventions come out of my thought. So that's the way to think about assignments. And if you go to the next slide, please. Part of what's important with assignments is the language of the assignments. So kind of like getting down to the basics of like, if you sell your house, well, if you've ever bought or sold a house before, you know that there's all sorts of papers that you sign that define what it is you're buying or whatever it is you're selling. And the language really matters. So a little bit ago, I gave you the example of a situation where we were representing our client in a lawsuit against a former employee of a company that they bought. Well, there are a lot of what the dispute came down to is who owned what, and who owned what depended on the language of these different agreements. So it depended on the language of his employment agreement. It depended on the language of his separation agreement when he left, you know, that small startup company. And it also depended on the language of certain assignment agreements that he had signed while he was at the company. And that person thought that what he did when he left and started his own company, doing basically the same kind of thing he was doing with that former employer, he thought that he had found something that he was allowed to do based on all those agreements that he had signed. Our client just said, no, you don't have that right. And it came down to the language of the agreement. So that's where we put these caveats in, is that the language does matter. And there's actually a difference, for instance, between language in an agreement that says you hereby assign and do assign something versus saying that whatever you're doing shall be the property of your employer. Even though the language kind of sounds really definitive and meaningful, one gives the employer a lot of rights, whereas the other one gives the employer very little rights, actually. And that shall be the property and shall be assigned language actually is taken from a lawsuit that happened just recently, where Apple Computer was in a lawsuit with this person who was a professor at the University of Michigan. And that professor at the University of Michigan went and started his own spinoff company. And the dispute came down to, did he own the property, this intellectual property, or did the University of Michigan own that intellectual property? Because he had been working on this research when he was a professor at the University of Michigan. And the way the lawsuit turned out is, well, the University of Michigan didn't own it because the agreement he had signed with the University of Michigan said that whatever he invented while he was there shall be the property of the University of Michigan, and that wasn't good enough. So the language in these agreements is very important. But I think the takeaway from this assignment language is, just like if you're buying a house and you want to know exactly what it is you're buying, what the boundaries of your property are, these assignment agreements, the language in the agreements makes all the difference in the world. And even though the language might seem relatively clearer, little bits of difference in language can mean a lot of money. Just like that research and development director who left and started his own company, just like the University of Michigan professor who, spun out his own company from the University of Michigan. Little details do matter. An assignment of intellectual property is basically deciding who owns what. I see there's a couple of questions that came up. Do you want me to answer those questions or should we move on?
I think I answered, it was just about valuation of IP. Rich, your firm doesn't do valuation, right? We usually farm it out to accounting or brokerage firms like Ocean Tomo. There was an ask if there's a local contact. We can get somebody local contact, but like your firm itself doesn't value.
No, we definitely wouldn't. And frankly, I'd question whether a law firm's allowed to, at least in New York State. Connecticut
Right.
might be different, but
we do anything here. No.
in New York, I would question that you would even be allowed to.
Yeah,
But there are companies that specialize in that.
Yeah.
All right, well then, let's go to the next slide. So this slide, I think, is just kind of a transition into the next group of slides, which is if you're signing an agreement, what does all that stuff mean? Okay. And kind of like I use the example that if you buy, or if you download an app on your iPhone and they have these terms and conditions, which everyone just says agree to without even knowing, well, I shouldn't say without knowing. Most people, when they click on that agree to, they're just wanting to use the app, but they don't really necessarily pay attention to what it is they're signing on to. Well, in the concept or in the context of like an app on your iPhone, it might not matter very much. But if you're starting a company or you're building your own business or you're working for somebody else, that language might be very important to you. And agreements tend to have certain elements that are in common with them. One is defining what the intellectual property is. What are the covenants associated with it? So in other words, what are you agreeing to do or agreeing not to do? That's what a covenant is. There's certain representations you make in the agreement where you're promising things to somebody else, promising that you own things or promising that you don't own things. Indemnification, if there's a lawsuit, who's responsible for what? Assumption of liabilities, who's liable for what? Severability, can you get rid of this agreement down the road? What are the confidentiality provisions? How do you terminate an agreement if the deal goes south and you don't want to be in the agreement anymore? What happens if you're bought out? You say you start a company and decide to sell it. How does that agreement bind on successor companies? And then what's the governing law? And like somebody asked earlier, if you do have a dispute, does it go to a federal court? Does it go to state court? Does it go to arbitration? What venue decides a dispute between the parties? So with that, maybe we can go on to the next section, which is terms.
Well, let me ask you this. We were supposed to go for an hour, and we've now gone past an hour. And frankly, if we beef up our next section, we'll have a whole other hour to talk. I'm wondering whether or not we stop here and take questions and then come back, if Doug is okay with that, and go over all these terms to the extent people would like to have a deeper dive into the important key terms of these agreements. Rich and Sarah, I'm absolutely accepting of your position on these. I just wanted to throw that out there, and Doug too.
Yeah, that makes sense. So unless Sarah disagrees, let's open up the discussion to questions, and then we'll see where it takes us.
And Doug, also, that works for you?
Oh, yeah, that'd be fine. I got a few things on the chat. Did we cover all the chat questions?
Yes. At this point, I think we have. But I think John Cunningham has a question. Maybe not. Does anybody have any questions for us about the different types of agreements and circumstances?
Yeah, I got a basic question here. So if we're brainstorming in the classroom and we come up with an invention, who's the inventor?
Joint inventorship.
So everybody in the classroom is now an inventor?
Good question.
So maybe I could give a starting answer to that, because this is something that I've seen come up a lot. And it actually kind of builds on a question that somebody asked earlier about the idea of what is conception. Can someone mute? Anyway, conception, and this goes to what Doug was just asking, there's a difference between having an idea, because people have ideas all the time, and having an idea about a fully formed invention. And that idea about a fully formed invention is what's called conception. So having an initial idea, you think about it, most ideas are more just kind of like a starting point for a research project. And it's going to take some time to kind of decide, does this idea work? If it does work, what does it take to make it work? What are all the details involved? And that difference between a basic idea, like an idea that comes up in class, and conception is when you've taken those next steps to figure out, okay, well, how do we take this kind of hazy idea and turn it into something real? Then after you've taken that idea and turned it into something real, which is called conception, before you can apply for a patent, then you have to do what's called reduction to practice, which is where you put that idea into either enough words that somebody else can read it and decide that, yep, they really did invent this, or actually make some sort of a working model and proving that this idea actually works in practice. So to kind of close the loop on Doug's question, and then I'll turn it over to Sarah and David, because they might have different ideas or different thoughts. The idea is kind of like the starting point for an invention, but before it really is an invention, you've got to actually figure out how to make it work. So it's kind of like Thomas Edison with the light bulb. A lot of people had the idea that, boy, it'd be great if we could have a source of light other than a candle, but actually figuring out how to make that idea work as a working light bulb. You know, you look at Thomas Edison, and at least, you know, urban folklore says that he tried 1,000 different things or whatever it is before he finally figured out how to make the light bulb work. It's those 1,000 steps to actually make something that works that takes you from an idea to something that's a patentable invention.
Sarah, do you have anything to add to that?
Yeah, I think that was good.
Yeah, okay, so my experience is this, right? I used to work with a defense contractor that would develop intellectual property, and they'd have invention disclosures that would have like 20 people on the listed as co-inventors, right? And in part because they would get an inventor award, which was always terrific for everybody named as a co-inventor, except for the fact that they weren't all co-inventors. You know, you have to do more than bring your what maybe Rich already said exactly this. What you're adding to the equation has to be more than what one of typical skill would bring to the table based on common knowledge, right? So that if someone says, you know, in order to bolt two things together, we should use rivets or screws, and that is common knowledge and adds nothing to the inventive quality of the thing you're inventing, that person is not an inventor, even if they're sitting at the table and they happen to identify, you know, basic level stuff. Or sometimes people were named inventors because they happened to be in the room and the inventors felt like, well, we're all together, we're all inventors. It's important to realize that what is and what is not an inventor, because by identifying people that are not inventors on your patent applications, there is a question about inequitable conduct before the U.S. Patent Office, and that could result in invalidating or rendering your patents unenforceable. So you do want to make sure that whoever is actually named an inventor is someone who's contributed to the inventive concept, which is something that's going to be required to advance your invention over the prior art and to enable you to get a patent. There's a lot there to digest, and we can help walk you through it, but just know that not everybody in the room or everybody who spews a concept is an inventor to your invention. That was good, Rich. Thank you. The feedback we received.
Thank you.
I agree. That was very good.
Any other questions or that anyone in the group has?
Well, I hope everyone will join me in thanking the speakers for coming in. Dave, Rich, Sarah, that was great. I really appreciate it, and I know everybody else does too. And for sure, we're going to have you guys back. But this will be the last IACT presentation of the year. There may be some sort of a holiday party, but I haven't set out the details yet. So I'm going to work with the board, and we'll see what we can come up with.